I think you'll want to stay tuned for the entire 3 hours. We're going to take our time here. And we're not going to put smiley faces on things and candy coat things because you're mature and you deserve the truth. Eric Holder was held in contempt a few hours ago. And the majority on the Supreme Court, led by Chief Justice Roberts, held you in contempt this morning. John Roberts apparently has evolved. Didn't take him that long. And the accolades from the left have already started. With the Obamacare and Arizona decisions, Roberts' activism is now firmly evident. Arizona was a brutal attack on the 10th Amendment and an expansion of the federal preemption power beyond what actually is provided in the Constitution. And the decision today, as I will get into it in some great detail, is a brutal assault on individual sovereignty. Now we have something akin to the Warren Court. It's still evolving, but we'll find out one day, I'm sure. And there are conservatives out there. It's painful to watch these people bending over backwards to pretend this was a great victory. But they're wrong. They're dead wrong. Just because 5 lawyers in black robes, one of whom was purported to be conservative, a man I knew a long time ago, issue a decision of the sort that they issued, doesn't make it proper. As a matter of fact, this decision I would go so far to say is lawless. Absolutely lawless. That's why people are stunned. Wow, where did he come up with that? He concocted it. More in a moment. Now, we had Anthony Kennedy of the 4 dissenters who wanted to throw the entire Obamacare law out. The entire law. The Chief Justice saved it under an absurd, a truly absurd and truly stupid argument that I'll get to, as I said, later. Chief Justice John Roberts saved Obamacare despite its multiple constitutional violations. We had 4 justices, including Kennedy, who wanted to throw the entire thing out. And I hear some conservatives claiming, wow, we narrowed the Commerce Clause jurisprudence. Are these people serious? I also hear the talk about politics. Well, now we're really going to have to win this election. That's all quite true. And I'll talk about that later. But how do we fix the Constitution? We can repeal Obamacare. We damn well better. But how do we fix the Constitution now that yet again it's been abused? Now that yet again a provision of the Constitution has been used, misused, to support a government program that is a direct assault on the individual. How do we fix that? New justices, Mark, really? You mean like Roberts? You mean like Souter? You mean like John Paul Stevens? And I could go down the list. You know, I was on Neil Cavuto's show yesterday, and he made a point. He said, some of these justices, they may be affected by how they're perceived by the media and the public. And I said to him at the time, it's true, but it only happens to Republicans. They seem to get this disease. Those 4 leftists on the court, those 4 left-wing judicial activists, there was never any doubt about what they were going to do. They wanted to run wild with the Commerce Clause. Why? Why? Because they're statists. Just because they're dressed up in robes doesn't mean they're not what they are. So the bottom line with the Roberts court decision is you can't regulate inactivity, but you can tax it. Wow! What a win for conservatives. He narrowed it. But wait a minute, you can't regulate inactivity, but you can tax it? And why would you tax it? Well, I think you tax inactivity to force people to do something they may not want to do, right? Now we're mincing words, aren't we? Like good judicial activists. So those who can afford assurance but don't have it are required to buy it, or they're going to be taxed. And the word tax in this context was never used by Congress. Ever. Quite the contrary. And I'm not going to bore you with the audio. We have it too. They insisted, as did Obama, it's not a tax. And then there's Roberts. But it is a tax. No, it's not a tax. Yes, it is a tax. No, yes, no. Well, what is it? It's whatever John Roberts says it is. So today it's a tax. And yet yesterday at this time, it was a penalty. Mark, why does that matter? Because the Constitution explains what kind of taxes the federal government can lay, and beyond the enumerated taxes, it can't lay any. And the Supreme Court actually has precedent on this point. Lots of it. None of which supports what John Roberts did. None of it. Now, let's do something. Take our time here. Stick with me. Now, what kind of taxes are permitted under our federal Constitution? Well, there's a tax that's called a direct or a capitation tax. Mark, what in the world is that? It's a tax on the individual. The Constitution requires direct or capitation taxes, a head tax, if you will, to be apportioned among the states. That means each state must pay its portion of the total tax based on the state's percentage of the general population. Very confusing, isn't it? That's why it's never done. Then under the Constitution, there you can have an excise tax. But excise taxes require some sort of action or activity on the part of an individual. So surely this can't be that either, can it? No. What about an income tax under the 16th Amendment? Well, even John Roberts doesn't attempt to justify the penalty as an income tax, because if you're not doing anything, you're not creating income. So it's not a direct or capitation tax. It's not an excise tax. It's not an income tax. And you know what John Roberts says in response to all that? Oh, let's stop fiddling around with labels. Excuse me? It's not fiddling around with labels. Got all kinds of case law on how crucial it is. Let's not fiddle around with labels. Oh. Now, Roberts begins with an obvious and frankly goofy, almost condescending civics lessons at the beginning of his opinion, like he believes this decision will be read in every town square, and certainly on MSNBC. And after explaining how the national government can only exercise enumerated powers, he says this case concerns two powers that the Constitution does grant to the federal government, but which must be read carefully to avoid creating a general federal authority akin to the police power. That is, police powers are reserved to the states. And as soon as he's paying lip service to the limited federal power, he carries on with a jumbled, bizarre, thoroughly inconsistent legal analysis. Ladies and gentlemen, I've spent a career reading court decisions. His part of the majority opinion. Well, I was going to say it's stupid. It is truly incoherent. It's terrible. He gets the Commerce Clause and the Necessary and Power Clause analysis correct, but he contorts the tax clauses, as I explained, beyond recognition. I don't even think he understands them, to be honest with you, because they can get complicated. Now, let's walk through this. You ready? Or should I take a break, Mr. Producer, and we'll get back to the different aspects of the decision, and I'll sum it up. What I notice is a lot of people want to conflate the constitutional stuff with the political stuff. We're going to take this step by step so you can understand what, in fact, a disaster this is. So you'll know more than George Will and Charles Krauthammer and several of the others who are saying, well, they confined the Commerce Clause issue, and now it's political, so let's go get them. I'm not opposed to the latter. But let's understand what happened to our Constitution today. And let us never forget that Constitution belongs to us. Not to temporary politicians, not to judges. It belongs to you. This decision is so absurd. It's so internally contradictory that if I were John Roberts, I'd be embarrassed to have my signature on it. We'll be right back.
Mark Levin.